Hang on. Okay, so obviously this wasn't supposed to happen tonight. But just like fucking last Thursday, when the circuit court ruled for Gavin Newsom, literally 2 hours later, the what do you call them? The freaking Ninth Circuit Appeals Court ruled for Donald Trump. So here we are, same freaking thing. I'm trying to pull up the decision right now. Let's see. Download. Okay, here we are. Out of the Ninth Circuit Court of Appeals for publication in Gavin Newsom versus as the governor of the state of California versus Donald J. Trump in his official capacity as president, an appeal for the United States District Court for the Northern District, Charles R. Breyer, argued and submitted 2 days ago. Let me make sure this is filed today. Yep. Before Mark Bennett, Eric Miller, and Jennifer Sung. We listened to this. We listened to a bunch of this earlier today, about 5 hours ago. What's up, Lean Back? What's up, Pilgrim? I will answer your answer in just a second there, Pilgrim. But this is huge. In 10 USC 12406, that's the statute that basically says, and again, let me pull it up. History, I've got it in here somewhere. What's up, Margaret Riddle? 10 USC 12406. This is the statute in the U.S. Code that says when the president is allowed to federalize the National Guard, that whenever the United States or any of the Commonwealths or possessions is invaded, when there's a rebellion, and this is the one that they kept talking about, when the president is unable with the regular forces to execute the laws of the United States. How do I get rid of this? There we go. Okay, I'm going to bring this up here. In 10 USC 12406, Congress authorized the President of the United States to call into federal service members and units of the National Guard of any state, whenever one or more of three conditions are satisfied. In responses to disturbances in L.A. stemming from federal enforcement of immigration laws, the president invoked this section and only that statute to order 4,000 members of the National Guard into federal service for 60 days. Now, remember, a lot of people were talking about how he did not invoke the Insurrectionist Act. The state of California and its governor, Gavin Newsom, sued the president in federal court. Plaintiffs alleged the defendant's actions were ultra-virus and violated the 10th Amendment to the United States Constitution. Remember, the 10th Amendment says that any law or any right not delegated to the Congress in this document being the Constitution or the Bill of Rights, any law not delegated to the Congress is returned to the states and to the people. They also alleged the Secretary of Defense and the Department of Defense violated APA, the Administrative Procedure Act. They applied for a TRO and received it, and then we issued a stay. We issued an administrative stay of the district's court's order pending our adjudication defendant's emergency motion for a stay. We now grant the stay. Defendants have made the required strong showing that they are likely to succeed on the merits of their appeal. We disagree with defendants' primary argument that the president's decision to federalize members of the California National Guard under 10 USC 12406 is completely insulated from judicial review. Remember, one of the big things they were arguing was that you do not get to review how we do this. They disagree. Nonetheless, we are persuaded that under long-standing precedent, interpreting the statutory predecessor to 12406, our review of that decision must be highly deferential, meaning that whatever review we give it, we must give the highest level of deference to the president. The president is the one that he's the commander-in-chief. He is the chief executive. He is the one that the people have put in power. It is not our job to oversee every single thing he does. It is his job to make the decision, and it's our job to determine whether or not that decision is constitutional. Affording the president that deference, we conclude that it is likely that the president lawfully exercised his statutory authority under 12406 Section C or 3, which authorizes federalization of the National Guard when the president is unable with the regular forces to execute the laws of the United States. Additionally, the Secretary of Defense's transmittal of that order to the Adjutant General of the California National Guard, who is authorized under California law to issue all orders in the name of the governor, likely satisfied the statute's procedural requirement that federalization orders be issued through the governor. Remember, one of the things that the California argued was even if he can issue the order, the process says that the order has to go to the governor. It says in Section 3, the president may call into federal service members and units of the National Guard of any state in such numbers as he considers necessary to repel the invasion, suppress the rebellion, or execute those laws. Orders for these purposes shall be issued through the governors of the states. So California argued the order was not given to the governor. It was given to the adjutant general. The Court of Appeals here is saying that the adjutant general is able to issue all orders in the name of the governor. So there is no bypass of the governor here. And even if there were a procedural violation, that would not justify the scope of relief provided by the district court's TRO. Let's see. Okay, we all know the background and procedural history. Appellate jurisdiction. Ooh, Margaret, I'm going to need to talk to you more. Ordinarily, we lack jurisdiction over the appeal of a TRO. I did not know that. At this time, however, we are not considering an appeal of a TRO, but rather a defendant's motion for a stay of the TRO pending appeal. We have jurisdiction to grant such a stay under the All Writs Act. Let's see. Standard review. Whew. Okay, so when determining if the appeals court should stay a TRO, these are what they look at. One, whether it is leaned back is the Court of Appeals for the Ninth Circuit. One, whether the stay applicant has made a strong showing that he's likely to succeed on the merits. Whether Donald Trump has made it pretty clear that he's probably going to win. Two, whether the applicant will be irreparably injured absent a stay. If the president isn't allowed to maintain control, then the National Guard are going to be removed from LA. And so having to go and win in district court and then recall the National Guard is going to cause more harm. Whether issuance of the stay will substantially injure the other parties interested in the proceeding. And four, where the public interest lies. So number one, likelihood of success. Let's see. Political question doctrine. I love this thing. Defendants argue that the claim challenging the president's order federalizing members of the National Guard is not justiciable under the political question doctrine. We disagree. Probably fair. In general, the judiciary has responsibility to decide cases properly before it, even those it would gladly avoid. Again, this is the same case that Breyer cited in his decision to the TRO for the TRO. He clearly does. No one wants to hear this case. Let's see. I want their decision. They say that the political question doctrine does not bar judicial review. Scope of review. See, if you go to like the end of the sections, it usually has a pretty good what's it called? All right, they don't have to tell you what standard of review they're going to use. Application. Under a highly deferential standard review, defendants have presented facts to allow us to conclude that the president had a colorable basis for invoking 124063. They presented evidence detailed above of protesters' interference with the ability of federal officers to execute the laws leading up to the president's federalization of the National Guard on June 7th. There is evidence that the day before protesters threw objects at ICE vehicles trying to complete a law enforcement operation, pinned down several FPS officers defending federal property by throwing concrete chunks, bottles of liquid, and other objects, and used large rolling commercial dumpsters as a battering ram. I didn't see that. I'd love to see that video. In an attempt to breach the parking lot garage of a federal building. Plaintiffs' own submissions state that the same protesters threw objects, including Molotov cocktails, and vandalized property. So they're not just citing what Donald Trump gave them; they're citing what Gavin Newsom gave them. According to the declaration submitted by defendants, those activities significantly impeded the ability of federal officers to execute the law. Affording appropriate deference to the president's determination, we conclude that he likely acted within his authority in federalizing the National Guard. I don't care about procedure at the moment, maybe later. In addition to the merits, we consider three other factors in assessing a motion for a stay. Whether the applicant will be irreparably harmed or injured absent a stay. Okay, let's see. The last two factors merge when the government is the opposing party. According to Ken, both irreparable harm and the public interest weigh in favor of defendants, who have an uncontested interest in the protection of federal agents and property and the faithful execution of the law. The undisputed facts demonstrate that before the deployment of the National Guard, protesters pinned down several federal officers and threw concrete chunks, bottles of liquids, and other objects at the officers. Protesters also damaged federal buildings and caused the closure of at least one federal building, and a federal van was attacked by protesters who smashed in the van's windows. It is awesome, Lynn Hanger. The federal government's interest in preventing incidents like this is significant. It is well established that the need to safeguard the normal functions of public facilities is a substantial government interest. The legitimacy of the government's interest in the abstract of ensuring the public compliance while in or on government property with proper direction of law enforcement officers is apparent. Plaintiffs argue that the public interest, as California says, the public interest weighs against issuing a stay because permitting the use of the National Guard here would upset the constitutional balance of power between federal and state government. While we recognize that significant interests of plaintiffs are implicated here, plaintiffs' argument is, in essence, a merits argument that we have already resolved. The Constitution assigns the power to call forth the militia to Congress, and Congress has delegated portions of that power to the president. U.S. Constitution, Article 1, Section 8, Clause 15. Let us read that real quick. Constitution, Article 1, Section 8, Clause 15. Well, that gave me a fucking New York Times article. U.S. Constitution, Art 1, Section 8, Clause 15. Let's see. Where's the? I want the actual thing. I don't want an abbreviation of it. I don't want an annotation. Come on, give me the actual damn thing. The Congress shall have the power to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. Again, that's the creation of the power to call forth the militia. Congress in the U.S. Code that we've all been citing throughout this, 12406, says the president is allowed to do that. As discussed under the facts before us, we disagree that defendants have clearly exceeded the scope of their statutory authority, so they are acting in accordance with the constitutional federal-state balance. Expressing concern about what they describe as defendants' nearly limitless conception of 12406, plaintiffs argue that this case marks the first time that the president has invoked this to order troops to patrol the streets of a major American city. We emphasize, however, that our decision addresses only the facts before us. And although we hold that the president likely has authority to federalize the National Guard, nothing in our decision addresses the nature of the activities in which the federalized National Guard may engage. So again, and I've talked about this in the past, if I was Trump, what he needs to not do now is say, they can go do whatever they want. They can't. He needs to keep them on federal property and assisting with federal agents. Before the district court, plaintiffs argued that certain uses of the National Guard would violate the Posse Comitatus Act. The district court found the claim to be premature, and plaintiffs have not renewed it before us. We express no opinion on it. Again, the Posse Comitatus Act says that you cannot use federal troops to act as state law enforcement. And there are few exceptions, and they are basically protecting federal property. So as long as he remains in that exception, there should be no problem here. Plaintiffs also urge that the public interest is in their favor because the continued presence of National Guard members in Los Angeles risks worsening, not improving, tensions on the ground. And the federalization of the National Guard impairs the Guard's ability to perform critical functions of the state, including support for fighting forest fires and combating drug trafficking. These concerns are counterbalanced by the undisputed fact that federal property has been damaged and federal employees have been injured, and the evidence presented in the TRO hearing showed that the federalized National Guard members were engaged only in protecting federal personnel and property. Additionally, at least with respect to the issues presented here, plaintiffs' concerns have more bearing on the question of whether the president should have federalized the California National Guard, not whether he had the authority to do so. We also note that California's concerns about escalation and interference with local law enforcement at present are too speculative. We do not know whether future protests will grow to the deployment of the National Guard. Plaintiffs cannot rely on the predictability effect of government action on the decisions of third parties. Rather, they can only speculate about the decisions of third parties. And we do not know where emergencies may occur in California while the National Guard is deployed. Accordingly, at this time and on these facts, the remaining stay factors weigh in favor of defendants. For the reasons above, we grant defendants' motion for a stay pending appeal. So, where do we go from here? Gavin Newsom has just been handed a massive L, like monumental. And this is what I want to show real quick. Let's see. StreamYard, share this tab instead. The fight doesn't end here. The court, he's talking about the district court, rightfully rejected Trump's claim that he can do whatever he wants with the National Guard and not have to explain himself to a court. The president is not a king and is not above the law. We will press forward with our challenge to President Trump's authoritarian use of the U.S. military soldiers against citizens. Again, he actually might not be talking about the district court. He might be talking about this decision by the appeals court. Notice how also what is this coloring scheme? Blue. Oh, is this supposed to be like him? Orange? That's dumb. The claim that the court rejected Trump's claim that he can do whatever he wants with the National Guard is a lie. That's not what the court said. It's also not what Trump said. Trump didn't say I can do whatever I want with the state's National Guard. He said, hey, Gavin, you're not doing what you're supposed to do as the governor, and my agents are in danger. So I'm taking your soldiers because you won't do what you're supposed to do. We will press forward with our challenge to President Trump's authoritarian use of U.S. military soldiers. They're National Guard soldiers. They're not military soldiers. Against citizens. That's exactly, lean back. That is also a lie. That's not what he's doing. Let's see. Yeah, that's funny. I like that too. It's a good point. If the liberal Ninth Circuit shot you down, what makes you think the Supreme Court is going to agree with you? So again, what's going to happen? The place to go from here is I'm pretty sure that he's insinuating he's either going straight to the Supreme Court, which you can do by filing there's a motion, but I forget what it is. Or what he's likely going to do is request a full panel of the Ninth Circuit, and that's 11 judges. Is it 11? Let's see. I think it's 11 of the 26 judges that are available in that circuit. No. Hang on. Here we go. Okay. It is. Yeah, it's an 11 judge panel of the 29 judges in that circuit, 16 of which were appointed by Democratic presidents. This is a massive L for Gavin Newsom. I mean, he essentially, and look, this is the deal. Like I said from the beginning that this is not something Gavin Newsom needed to do, that this was a mistake. He likely has the ability to just completely wreck the command structure of the National Guard moving forward across the country. Let's see. Donald Trump said, let's share this. Nope, that's the wrong thing. This is what I want to share. Big win in the Ninth Circuit Court of Appeals on the president's core power to call in the National Guard. The judges obviously realize that Gavin Newsom is incompetent and ill-prepared, but this is much bigger than Gavin, because all over the United States, if our cities and our people need protection, we are the ones to give it to them. Should state and local police be unable, for whatever reason, to get the job done? This is the great decision for our country, and we will continue to protect and defend law-abiding Americans. Congratulations to the Ninth Circuit. America is proud of you tonight. You damn right we are. Let's see. Oh, geez, that's terrifying. Yeah, this whole thing right here, guys, this is a lie. That's not even the Ninth Circuit Court of Appeals right there. So that tweet going around saying that they've done this, that didn't happen. They actually basically ruled the opposite. They multiple parts of that law they struck down. But yeah, this is a big win. This is a very big win for the Trump administration. Like Caroline Leavitt said months ago, they're well aware that they're going to lose in district court a lot, that these judges don't care. They don't care what the rules say. They don't care what the law is. They just want their moments in the sun, and they just want to be able to say, I landed a blow for the resistance. But at the end of the day, the people that actually make the decision, the Court of Appeals, the Supreme Court, they know what the rule is, and they're going to win there. Margaret, thank you so much. I really appreciate that. Well, I'll be honest. I was hoping for a little bit more of a gotcha in the decision, but that's a pretty awesome decision. Yeah. Well, that's going to be it, guys. Quick little 26 minutes there. Hope y'all had fun. We all had, I had a lot of fun laughing at that idiot. Peace out, guys. See y'all this weekend.